So can I? Oh.
Go ahead.
What incentive would you have to do anything if you won? If you win and mere knowledge isn't enough, why would you bother to send out any notices in the future? What would your obligation be?
For the simple reason that Cox is a good corporate citizen that cares a lot about what happens on its system. We do all sorts of things that the law does not require us to do.
But don't you do these notices in an effort to get the safe harbor, and aren't you sending these notices to avoid liability? You would have no liability risk, right, if you win going forward?
That is correct, but I want to underscore my answer to...
Let me stop you there. I mean, if purpose is the test, very few bad actors come out and say, I intended to do something awful. You infer it from circumstances, and a jury could still infer purpose from your knowledge and some other actions, right?
So, but Your Honor, my answer is no, and I agree with you that the way one conducts this analysis is not to say, oh, purpose is the test. The way one conducts the analysis is to
So you disagree with the government on that?
No, I don't think the government is saying that purpose is the standard.
That's exactly how I read its brief. Perhaps I'm missing something, and Mr. Malcolm can help me there.
What the government and we both contend is that there are acts that can be, from which one can impute intent, and in the context of a seller, in particular a seller of communications technology, this court has held that unless it is a technology that is incapable of multiple uses, that is non-infringing uses, you don't infer intent from what is an equivalent.
We don't have to go that far, though, to recognize that the jury instructions here were improper, do we?
No, you don't have to go that far to recognize that both the jury instructions here and in particular the Ninth Circuit's holding that the instructions as applied to this set of facts could sustain liability.
So let me ask you if I've got it right, okay? The narrowest version of your argument, perhaps not everything you want. That the statute doesn't mention secondary liability, so we should be cautious. And in fact, in Central Bank of Denver, we refused to infer secondary liability in a statute that had no explicit cause of action. But here we are, Sony did it, so okay. The narrowest version of that requires purpose. And we've said that many times, knowledge isn't enough. There are various ways one can infer purpose, such as through inducement or the fact that the thing you're selling doesn't have any other lawful use. There may be other ways to infer purpose, and the jury instructions here didn't contain purpose, just knowledge, so therefore reverse. Anything wrong with that syllogism?
There's nothing wrong with the syllogism, just one quibble. We're not challenging the jury instructions. We're making a J-Mal argument. But yes, everything else you said, I completely agree with. That what the Fourth Circuit did was to say that continuing to provide internet service with the knowledge that someone on that account is likely to infringe again, that is the culpable act. And that is just absolutely not correct. This court rejected that exact theory in Twitter. I would remind the court to the questions asked earlier about whether Twitter goes that far. There was knowledge in Twitter of actual accounts. I understand it was not knowledge of specific acts of terrorism, but knowledge was very much a part of that case.
So is it your view